Are you behind on your car note? Or what about that loan that you took out that you're no longer making payments on and now you owe that financial institution? Now listen, I'm not asking you how much you owe. I don't even care about that. The question is there anything actually owed? Can you prove that the contract that you have is reasonable and lawful? I just want to know. Now, what you need to know is that every financial institution is a corporation. They are fictitious entities. Corporations can only do business with corporations. Financial institutions cannot do business with natural men and women. Breathing souls. Now, don't get lost. Hang in there. It's going to all start making sense. I just want to say this is just for educational purposes. This is not legal advice. I am just the messenger. See, it's always something. All of a sudden, my mic stopped working. But listen, we're going to get through this video. So now that you know that corporations can't do business with natural men and women, shouldn't that tell you that somewhere deception has taken place? Natural breathing souls like men and women can't exist in this legal system. The United States. The United States is a commercial for-profit company that does businesses with other businesses. So fictitious entities like commercial companies, they can't do business with natural men and women. They can only do businesses with pieces of papers, contracts, agreements, and things you got to sign. Like I said before, somewhere deception has taken place. Now, these financial institutions can't force you to do anything, but they damn well can deceive you and have you signing papers and agreements and contracts that you barely understand that's 30 pages long. Now, the key to all of this is for you to comprehend that natural men and women can't do business with corporations. Now, it's up to you to do your research. You got to study and figure out, where did this deception come in at? Where did it actually start? So if you are signing documents with corporations and financial institutions and you are a party to a loan agreement, then how is that contract reasonable and lawful if they can only do businesses with other businesses? Well, let's say you went to the dealership to get a car and you're financing through Wells Fargo. Well, Wells Fargo should be able to provide you a contract binding both parties to that loan agreement, meaning you and them. There are certain conditions that they must meet in order to hold you liable for a financial obligation. The same conditions would apply if you had got a summons and a financial institution was trying to sue you. Like I said before, this is all educational purposes, but you did hear me say that they can only do businesses with other businesses. You are a natural soul. You are a breathing soul. How are you doing business with them? That means the contract, the loan agreement has to be frivolous because there is some information that's missing that you are unsure of. This conversation is not about you trying to get out of the contract. Your notice to these financial institutions should never be to dispute the alleged obligation, but yet agree to pay any financial obligation that you might lawfully owe under the condition that they provide you full disclosure of the loan agreement. All you're doing is asking questions and looking for them to validate this alleged obligation, providing a wet ink signature of yours and theirs, all account information of the loan agreement, as well as equal consideration of interest from both parties. They should be able to provide you lawful terms and conditions. You are not denying anything. You are conditionally accepting upon proof that they provide you a lawful contract that's holding you liable for the obligations. So if you got a car note that you fell behind on, or they sending you letters trying to take you to court, or a loan you took out that you can no longer pay, then you need to be sending these financial institutions a notice to receive the full disclosure of the records. You need full disclosure of everything. If you're going to hold me liable for something, I need account information. I need you to provide this to me. You do not want to dispute anything. You are asking and you need to receive. You're not going and arguing with anybody. We are just asking for documentation. That is my rights. So your first notice should be to receive the full disclosure of the loan agreement. If they do not respond, you send them a second notice, a notice to cure. You are giving them a chance to prove the alleged allegations. If they do not respond and they just shut up and go mute in the legal system, that is acquiescence. They have fell out of honor. They did not honor your request. Then you want to send them a notice of default. This is how you get your remedy when you are coming after these people. You want to see what the bookkeeping is like. You can't just accuse me of something and don't provide me information letting me know who has interest in this, whose signature is where. I know that businesses can't do businesses with natural men and women. So how is this contract lawful? You have to look at the bookkeeping. You have to look at the details of the contract. If they don't provide you these things, if they go mute, acquiescence, 9 times out of 10, they're just going to discharge the whole debt because you're asking for things that they cannot provide. This is not about beating the system. This is not about beating the banks. This is about someone violating your rights. So if you set your administration process up in that order, sending a notice to cure, a notice of default, 9 times out of 10, they're just going to discharge it, because they cannot provide what you're asking for. There's only one signature on your contract. Take a look at your contract. Read your contract. It's only one signature and it's yours. There should be two. You have to ask for the right information. It's not about you getting over on the banks, but the banks is getting over on you. It was a deceptive form. You're telling me that you gave me something, but the paper says otherwise. So you have to study and really figure out who you are, what role you play. Your name holds value. It's about asking the right questions, being very wise, putting them up on notice in writing, even if they try to take you to court, because there are certain things that you are asking them that they can't provide. They can't provide certain information. This is why we got to be careful when we are signing these contracts, because these are deceptive forms. 2 signatures should be on your contract. It should show on paper that there's some type of interest from both parties. And it's not. So if you have accounts on your consumer report that you feel is not reasonable and lawful, you have the right to have them removed. You have to administrate your process the right way. You don't want to call anybody over the phone. You don't want to send any emails out, okay? You need to click the link in my bio and get the 3-letter powerful bundle kit that will stop these institutions in their tracks. Don't wait to be great.